a doctor's office, a waiting room, a prescription pad. That is all it took. One signature, one small white tablet, and a patient who trusted their physician completely. Across America, millions of those moments happened every single day throughout the late 1990s and into the 2000s. And behind every one of them, the same company, the same family, the same promise. That this pill was different, that addiction was rare, that the science was settled. It was not. More than 500,000 Americans died of opioid overdoses between 1999 and 2019, according to the Centers for Disease Control. A dynasty built on philanthropy, on museum wings bearing their name, on the language of healing, and on a machine that kept running long after the damage was undeniable. How does a family get there? By the mid-1990s, the Sackler family's company, Purdue Pharma, was not a household name. But it was about to become something far more powerful than famous. It was about to become indispensable. The family had already demonstrated decades earlier that it understood something most pharmaceutical companies did not, that the way a drug is sold matters as much as what the drug does. Arthur Sackler, the eldest of three brothers, had built a reputation in pharmaceutical marketing in the 1950s and 1960s that was, by any measure, decades ahead of its time. He understood physicians as an audience. He understood that advertising in medical journals, that detail men visiting surgeries with samples, that the architecture of trust, these were levers that moved markets. Arthur died in 1988, before OxyContin existed. His brothers Raymond and Mortimer and their descendants held the company, but the philosophy endured. OxyContin launched in 1996, and from that moment, Purdue Pharma deployed a sales operation of extraordinary scale and precision. According to findings in multiple state attorney general investigations and the 2020 federal guilty plea by Purdue Pharma itself, the company trained thousands of sales representatives to tell doctors that OxyContin's controlled-release formula made it less prone to abuse than short-acting opioids. The claim rested on a single paragraph in a 1980 letter published in the New England Journal of Medicine, a letter that had never been designed as a clinical study, had never been peer-reviewed as evidence of addiction rates, and which the journal itself later said had been widely misrepresented. Purdue used it anyway. Sales representatives visited doctors who were already high prescribers. They offered patient starter coupons for free initial prescriptions. They pushed dosage escalation. Between 1996 and 2000, OxyContin sales grew from approximately $48 million to nearly $1 billion annually, according to financial data cited in court proceedings. By 2003, it was generating over $1.5 billion per year. The Sackler family members who sat on Purdue's board were not passive shareholders. According to documents unsealed as part of the Massachusetts Attorney General's lawsuit filed in 2019, board members received detailed sales reports, approved marketing strategies, and were kept closely informed of prescribing trends. The family also gave. Generously. Visibly. The Sackler name appeared on wings of the Louvre, the Guggenheim, the Metropolitan Museum of Art, the Tate Modern, Harvard, Oxford. The philanthropy was real, the checks cleared, the names were carved in stone. And that stone, for a long time, made everything else harder to see. But the prescriptions kept climbing. And in emergency rooms, in rural counties, in suburban homes, something else was climbing too. The first official warning arrived early. In 2001, the Food and Drug Administration cited Purdue Pharma for false and misleading advertising related to OxyContin, finding that the company had understated the drug's abuse potential and overstated its safety profile. Purdue revised its materials. The sales force kept growing. Here is what almost no one outside the company knew at the time. According to internal documents later produced in litigation, Purdue's own researchers had data by the late 1990s showing that patients were crushing and snorting OxyContin tablets to defeat the controlled release mechanism. The drug was being abused. The company knew, and according to the Massachusetts Attorney General's complaint, certain board members were informed. The response internally was not to pull back. It was to plan a new formulation, one that would be harder to abuse, while the existing formulation continued to sell. That reformulation would not reach the market until 2010. In the intervening years, more than 200,000 Americans died of prescription opioid overdoses, according to CDC data. Re-engagement beat, and here is what the public record would later reveal that almost no one anticipated. The Sackler family was not simply receiving dividends from a profitable company. According to the 2021 bankruptcy proceedings and court-filed financial analyses, members of the Sackler family had transferred approximately $10 to $11 billion out of Purdue Pharma between 2008 and 2017. Wire transfers, shell entities, accounts in jurisdictions including Switzerland. The money moved as the lawsuits began to accumulate. State attorneys general started filing. West Virginia in 2001, Kentucky in 2007, multiple states through the 2010s. Each lawsuit produced new document disclosures. Each disclosure showed a company that had been told repeatedly by its own data, by regulators, by the rising death toll, that something was catastrophically wrong. In 2007, Purdue Pharma and 3 of its executives pleaded guilty in federal court in the Western District of Virginia to misbranding OxyContin by claiming it was less addictive than it was. The company paid $600 million in fines and settlements. The executives paid a combined $34.5 million. None served prison time. The Sackler family members who sat on the board at the time of that conduct were not named in those 2007 charges. They continued to run the company. OxyContin continued to be the company's primary revenue source, and the transfers out of Purdue continued. By 2017, more than 47,000 Americans died of opioid overdoses in a single year, according to CDC records. The majority of those deaths, by that point, involved illicit fentanyl. But the prescription opioid epidemic that OxyContin had helped ignite had already reshaped the country's relationship with these drugs, flooded communities with tolerance, and created the conditions for that second wave. Investigators in multiple states were now looking not just at the company, but at the family. The question was no longer whether Purdue had acted wrongly. That had been established. The question was whether the people at the top had personally directed it, and whether the money they had moved could be reached. In September 2019, Purdue Pharma filed for Chapter 11 bankruptcy protection in the Southern District of New York. The filing was not a surprise. It had been preceded by a wave of litigation, more than 2,000 lawsuits from states, counties, cities, and tribal nations that had made continued operation untenable. What the bankruptcy filing did, however, was trigger one of the most contested legal processes in American corporate history. The Sackler family proposed a settlement. In exchange for contributing funds to a compensation trust for opioid victims and surrendering ownership of Purdue Pharma, family members sought what is known in bankruptcy law as a third-party release. a legal shield that would protect them from future civil lawsuits even though they had not themselves filed for bankruptcy. Re-engagement beat. And here is the mechanism that almost brought the entire settlement down. That third-party release had never been definitively sanctioned by the Supreme Court for use by parties who were not themselves bankrupt. It was a legal instrument being deployed at a scale and in a context that the courts had never fully tested. Victims' advocates called it a billionaire's escape hatch. The Department of Justice's bankruptcy watchdog formally objected. The original settlement proposed by the Sackler family offered approximately $4.5 billion. After years of litigation, appeals, and a Supreme Court ruling in June 2024 that struck down the third-party release mechanism as it had been structured, finding in a 5-4 decision that the bankruptcy code did not permit such broad releases for non-debtors, the settlement had to be restructured. Under the revised agreement reached in 2024, the Sackler family agreed to pay $6 billion into a settlement fund, relinquish ownership of Purdue Pharma, and the company itself pleaded guilty in 2020 to federal criminal charges, including conspiracy to defraud the United States and violating anti-kickback laws. Purdue Pharma agreed to pay more than $8 billion in penalties as part of that criminal resolution, though the actual amount recoverable in bankruptcy was substantially less. The individual Sackler family members, those on what became known as the Side A branch, descendants of Mortimer Sackler, and the Side B branch, descendants of Raymond Sackler, were not criminally charged in connection with the opioid crisis. The settlement they ultimately reached did not constitute an admission of wrongdoing by family members. Those facts are part of the documented record. What is also part of the record? The museums began returning the money. The Louvre removed the Sackler name from its galleries in 2019. The Tate followed. The Metropolitan Museum of Art announced it would stop accepting Sackler gifts. Oxford's Bodleian Library returned a donation. One by one, the carved stone began to disappear. Purdue Pharma, as it had existed, was dissolved. The company that had generated billions for one of America's most prominent philanthropic families ceased to exist as a going concern. The brand name OxyContin and the intellectual property associated with it became part of a new public benefit company structure under the settlement, intended by design to direct future profits toward abatement of the very crisis the original company had helped create. The opioid settlement funds began moving through distribution systems that were themselves complex and contested. Individual victims, or the families of those who had died, were eligible to file claims. The amounts varied. According to reporting by established legal and financial media covering the bankruptcy proceedings, many individual claimants received payments in the range of hundreds to a few $1,000s. The bulk of the funds were directed toward state and local governments for opioid abatement programs, treatment infrastructure, naloxone distribution, recovery services. The Sackler family members involved in Purdue's operations retained substantial personal wealth after the settlement. The $6 billion represented a significant sum, but it was drawn from assets that, according to court-filed financial analyses, represented a portion of what the family had accumulated over the years of OxyContin's peak sales. The family members were not left destitute. That is a documented fact, not an editorial judgment. The reputational consequences, however, were severe and lasting. The philanthropic identity that the family had spent decades constructing, the museum wings, the university endowments, the association with culture and healing, was systematically dismantled by the institutions that had accepted the money. That process was driven not by regulators, but by public pressure and by the decisions of the institutions themselves. The legal architecture of the case also left a mark. The Supreme Court's 2024 ruling on the third-party release mechanism has implications beyond the Sackler case. It narrows the circumstances under which wealthy individuals can use a company's bankruptcy to achieve personal legal protection. Future corporate collapses involving wealthy owners seeking similar shields will face a higher bar. The FDA, for its part, has tightened its requirements around opioid prescribing information. The DEA has increased scrutiny of prescription monitoring. Multiple states have passed legislation capping opioid prescriptions. These changes came after the deaths, not before. The CDC's documented toll, more than 500,000 opioid overdose deaths between 1999 and 2019, a figure that continued to rise through the subsequent years as illicit fentanyl took hold, represents a public health catastrophe that no settlement fund can undo. The people behind those numbers had names. They had families. The compensation that reached those families was, by most accounts, a fraction of the loss. The one lesson this case makes plain, without embellishment: when a company's internal data shows that a product is causing mass harm, and that data is not acted upon, the gap between knowledge and action is where the damage lives, and it compounds every single day that the gap remains open.